with decisions here in Delhi from both the single judge on the original side and also the division bench. The case has come to be known as the mosquito net wars in many quarters because the plaintiff, my client, Vestergaard Fransen VF, is the world's largest producer of disease-controlled textiles, which include long-lasting insecticidal mosquito nets, usually referred to as LLINs, in the global fight against malaria. So like so many misuse of confidential information and trade secrets cases, the case involves former employees of the plaintiff, and in this case, the former consultant of the plaintiff who, to use layman's language, stole the confidential information and trade secrets of their employer, the plaintiff, and then set up in competition with it. The trade secrets here were recipes for LLINs, long-lasting insecticidal mosquito nets, which are highly technical and were contained in a database called the Fence database, produced by and at the expense of VF by a consultant they engaged called Dr. Ulla Skermand. Now, LLINs are more than just average mosquito nets because they have to satisfy very stringent criteria set out by the World Health Organization. And very few companies have been able to develop technology in this area that actually works. A number of the criteria, for example, are that they need to be able to work and survive and retain their insecticidal capabilities in places like sub-Saharan Africa for 3 years in the field and survive at least 20 washes and still kill all the mosquitoes. Now, the Fence database, in addition to recording the recipes for various different versions of long-lasting insecticidal nets, also included experimental results data of tests conducted to nets made to those recipes. Now, what happened here is that the employees resigned, the development employees resigned from VF, and they incorporated a new business called BestNet Europe Limited, and they retained VF's consultant, Dr. Ulla Skermand, to develop a competing LLIN called NetProtect, using information contained in VF's Fence database. BestNet manufactures NetProtect here in India, with stage 1 of the manufacture taking place here in Delhi, and the actual stage 2 knitting of the yarn and final net production taking place in Tamil Nadu in a warehouse factory owned by a Mr. Sivasamy. So hence the action here in India and the litigation before the Delhi High Court. So looking at the law in England, which is replicated in many common law countries, to be protected by the law of confidential information, the information must, 1, be confidential in nature and have the necessary quality of confidence, and 2, it needs to be disclosed in circumstances importing an obligation of confidence. The rights conferred by the law of confidential information can be enforced against the recipient of such information and any subsequent third-party recipient of such information, even where the third party had no knowledge of its confidential nature when they received the information, so long as they subsequently become aware of the fact. So an action for breach of confidence is essentially based on conscience. For the conscience of the recipient to be affected, it must have been agreed or must be known that the information is confidential. And knowledge in this context is not limited to actual knowledge, and it can include what is sometimes known as blind eye knowledge. Now, there are no statutory rules for determining who the first owner of confidential information is, or to who the obligation of confidence is owed. Consequently, depending on the circumstances of a case, such an obligation may be owed to a person who generated the confidential information, or to a person who paid for the information to be generated. To bring an action for breach of confidence, there must also be disclosure of the information which is either actual or threatened. Now, in the case of Saltman Engineering Limited and Campbell Company Limited, which dates back to 1948 in England, it was stated that to be confidential, the information must have the necessary quality of confidence about it. Namely, it must not be something which is public property and public knowledge. In the case of Coco and A.N. Clark Engineers in 1969, Mr. Justice McGarry said that something that had been constructed solely from materials that are in the public domain might possess the necessary quality of confidence if something new and confidential has been brought into being by the application of the skill and ingenuity of the human brain. He said in the case, whether it is described as originality or novelty or ingenuity or otherwise, I think there must be some product of the human brain which suffices to confer a confidential nature upon the information. Now, in the mosquito net wars case here, there was no real dispute that VF's fence database had the necessary quality of confidence. Now, an obligation to keep information confidential can be imposed by contract. It can be implied because of the circumstances of disclosure, and it can also be implied because of the special relationship between the parties concerned, for example, employer and employee. In the case of Coco and Clark, it was said that one must consider a reasonable man standing in the shoes of the recipient of the information, whether they would have then realized that upon reasonable grounds, the information was being given to them in confidence. Here in the mosquito net wars case, there was actually an express contractual obligation of confidence imposed on Dr. Skirman. And the court also held that there were 10 cumulative reasons, and this is the court in the UK, I should say, held that there were 10 cumulative reasons for an obligation of confidence to be implied in his relationship with VF. Equitable obligations were also found to exist by the UK court for more or less the same reasons as the implied obligation of confidence. Now, confidential information can be protected for as long as it retains its confidential nature, which obviously can potentially be indefinitely. Think of something like the Coca-Cola recipe. But information can lose its confidential character by becoming out of date and ceasing to have any commercial value. So in some industries, this may mean that the secret would not be of value for very long. There are also circumstances where confidentiality agreements, as typically drafted, are limited in time. The difficulty, particularly in the case of former employees or consultants taking information which they subsequently use in competition with their former employer, is to determine whether or not the information that they are using is genuinely a trade secret. The courts have held that employees are entitled to use for their own or for others' benefit acquired information that forms their skill, knowledge, and experience. So the test that needs to be applied is whether the information in question can be fairly regarded as a separate part of the employee's stock of knowledge, which a man of ordinary honesty and intelligence would recognize to be the property of his employer and not to do with as he likes with. So this will differ on a case-to-case basis. This slide points out some of the issues that needs to be taken into account when considering and determining this test and whether or not the information is a trade secret. You need to look in the specific circumstances, the nature of the employment that existed, the nature of the information that's been taken, any evidence of the attitude of the employer during the course of the employment, what steps the employer took to protect the information during the course of the employment, and also then to look at the separability of the information and whether or not it can be separated from the individual's general skill, knowledge, and that should say experience at the end there. You've also got to look at the commercial value of the information to the business, and also, at a more wider level, the usages and practices in the trade. Now, in the mosquito net wars case, the UK courts and subsequently the courts in France, in a parallel case there, have held that the information contained in VF's fence database, and in particular the recipes and the bioassay results, that's the experimental data, constituted VF's trade secrets. The defendants argued that all the criteria under English law had not been met and there had been no misuse of the confidential information and trade secrets because they said they hadn't used the experimental results in VF's fence database. But the UK court held that you can't separate the recipes from the experimental results because the experimental results were used to identify which recipes were worth repeating. The defendants were therefore liable in the UK for misuse of confidential information. And the relief provided by the UK courts for misuse of confidential information includes injunctive relief, damages, or an account of profits. Interestingly, damages have also, in this case, been held to be recoverable in respect of products which don't embody a misuse of confidential information, but which are derived from a misuse of confidential information. And what that means is that when someone takes the confidential information and develops a product which misuses it, but they continue their development program, so over time they develop away from the misused confidential information, but they would not have reached that position had they not previously misused the confidential information. Iteration 2, iteration 3, iteration 4 of the product, which no longer embodied the misuse of confidential information, can still be liable for damages, and the plaintiff can recover damages in respect of those later products. Now, it's all well and good having a legal framework for the protection of confidential information and trade secrets, but if the procedural framework through the courts is absent or inadequate, then the legal framework is of little assistance to business. And the main problem with litigating confidential information and trade secrets, the purpose of which is to prohibit the dissemination of the trade secrets and protect them and prevent them from being disseminated further, is that a natural consequence of litigation is to place the subject matter in the public domain, thereby defeating the entire object of the litigation and destroying the confidentiality of the secret. Thus, in a country like Belgium, which has extensive statutory protection for trade secrets, there are actually relatively few cases to enforce such secrets through the courts, because the Belgian courts haven't developed adequate procedures to maintain the confidentiality of the secrets in the litigation itself. In the UK, the courts are sympathetic to this, and the position of both plaintiffs and defendants in ensuring that both parties' confidential information are maintained out of the public domain, and there are structures that can be put into place relatively easily in order to preserve the confidentiality during litigation. These include the setting up of confidentiality clubs of lawyers and named individuals from the parties to litigation who provide confidentiality undertakings to their opponents and to the court, the breach of which can result in personal liability both under contract and also being held in contempt of court. Private closed in-camera hearings in which members of the public who are not members of the confidentiality club are excluded from the court are also held in such cases. And when the court renders a decision, the court will publish redacted judgments for public consumption in which the confidential information and trade secrets are removed or codified, and it will only circulate confidential versions of the judgments to the parties who are members of the confidentiality club. Now, this issue actually arose here in India in the parallel case before the Delhi High Court, where the parties on both sides were extremely concerned as to the adequacy of the protection of their respective confidential information and trade secrets and the risk of them being placed on the public record and referred to in open court here in India. The parties were agreed that simply filing the confidential information at court under sealed cover was insufficient in such a highly technical trade secrets case like this, where detailed evidence and submissions were essential for the fairness of the litigation and to enable the parties to have safe access to the other side's evidence. This was considered by a division bench of the Delhi High Court, consisting of Mr. Justice Valmiki and excuse my pronunciation, I think it's Mr. Justice Mehta. In their judgment, the division bench stated the following: "We also direct that the learned single judge, before directing the production of the documents of the defendants, the learned single judge may first devise a procedure to ensure as to how the information, documents, database of which production is sought and which pertain to the product of the defendants, that the same be kept confidential so as to not prejudice the defendants in any manner, besides also further providing how such confidential information of the defendants will be looked into and by which person and in what manner, and other relevant matters so as to decide the injunction application of the plaintiffs, considering the fact that vital stakes of the parties are involved." Eventually in 2012, the learned single judge, Mr. Justice Mamoon Singh, pronounced his decision following the direction of the division bench I've just referred to. The judgment itself is quite extensive, but to paraphrase it, he stated, "In order to devise a procedure to ensure the confidentiality of the information, documents, database, etc., the following directions are passed ordering production of the same. 1, that the confidential documents be lodged. 2, that the Registrar General take the confidential documents in sealed covers boxes on record. 3, that undertakings voluntarily provided by identified members of a confidentiality club are applicable to the confidential documents. 4, that whenever these relate to or require any confidential documents to be relied on or quoted from, or arguments addressed thereon, these will be conducted in camera or in judges' chambers, with only the members of the confidentiality club permitted to be present. And 5, that the Registrar General will keep the documents in sealed covers under lock and key and allow access to the confidential documents only to the members of the confidentiality club on specified terms, including to temporarily deseal them for inspection by members of the confidentiality club. Now, in the UK, in most cases, the opposing party's lawyers, who are members of the confidentiality club, are entitled to hold copies of the opposing side's confidential documents for the duration of the trade secrets litigation. However, save for the requirement here in India that the confidential documents be lodged with the Registrar General before him, the regime ordered in India in the Mosquito Net Wars case in 2012 mirrors to a very large extent the typical procedural practice here in the UK. And I understand from discussions with counsel here in Delhi that since this 2012 judgment, the Delhi High Court has since adopted this same or a similar procedure in a number of other cases involving trade secrets. Thank you very much.